We will be providing you information on no-fault evictions and the processing of those no-fault evictions by the Los Angeles Housing Department. The information today is intended to be for landlords, but of course anybody in the public can join our webinars today. The presentation will be focused on how to file, where to file, what forms to file, and some general rules on the topic. If you have specific questions on your specific property, it is best to send those questions to us via an email app that we will be sharing with you so that a staff member who specializes in the area can respond to your questions. Once again, thank you for joining us. And my name is Emma Garcia, and I work for the Los Angeles Housing Department. The information today is regarding residential units in the city of Los Angeles. It is not intended for commercial units and not intended for properties outside of the city of LA. This is general information and is not intended to be legal advice. If you wish to seek legal advice, you may do so by contacting an attorney. The overview of the topics to be covered today are on the slide on your screen. We will begin by discussing the difference between properties or how to identify if your residential rental property is located inside the city of Los Angeles or in the unincorporated county area. Then we will review the two City of LA laws, the Rent Stabilization Ordinance and the Just Cause Ordinance. We'll move on to the legal reasons for eviction, including the no-fault reasons that require relocation payment to tenants. And we will also discuss the landlord forms that have to be filed to initiate a no-fault eviction process in the city of LA. And finally, how to contact the Los Angeles Housing Department. It is very important to be able to identify if the rental unit is in the city of Los Angeles. The reason for this is because there are different rules that cover the city of LA units versus unincorporated LA County versus other cities in the county. So we prepared a very simple slide with an image that shows the entire Los Angeles County area outlined in black text. The area that's shaded in red is the city of Los Angeles. The rest of the outline area is the county of Los Angeles, which may include other cities, for example, Pasadena, Glendale, Whittier, and so on. Those cities are located in the county, but they're not in the city of LA. The area that's not shaded in red, but outlined in the black ink is also, parts of it will also be the unincorporated Los Angeles County areas, which will follow the county rules. One very easy way to know if the rental unit is located in the city of Los Angeles is to look at the water and power bill that is paid for that unit. If it is paid to the Los Angeles Department of Water and Power, DWP, then that rental unit is located in the city of Los Angeles. Likewise, if the Los Angeles Police Department provides services to your area, that will also be an area covered by the city of LA. There is a more specific way to confirm that you are in the city, and that is by going to the website at cemas.lacity.org. When you go to that website, you will be able to enter your address, and if you find information on your address, it means that you are in the city. You can also go to neighborhoodinfo.lacity.org. Once again, neighborhoodinfo.lacity.org, and enter your address. If you get a message that says nothing is found, such as the one shown on the bottom left-hand side of your screen, then that means that address is not in the city. If you do get results, such as the ones on the bottom of the right side of your screen, that means the property is in the city. The results will give you information such as the mayor's name, the city controller's name, the city attorney, the city council district. Those are all indications and all information related to the city of LA. If your property is not in the city, then we suggest you contact the Los Angeles County. They may be reached at a telephone number, area code 833-223-7368. Or you can go to their website or send them an email so that they may provide you information about the county rules or can guide you to your specific city that may have its own rules. Once you have established that the rental property is located in the city of Los Angeles, then the next important piece of information to identify is whether or not the rental unit is regulated by the Rent Stabilization Ordinance or the Just Cause Ordinance. Both of these laws are city laws, and almost all residential properties in the city of LA will be regulated by either the RSO or the JCO. Properties that are regulated by the Rent Stabilization Ordinance or the RSO are properties that generally have been built prior to October 1st of 1978. There are some exceptions to that date related to the Ellis Act. So if RSO units were previously demolished and new construction was completed on the same site, in some cases, that new construction will also be subject to the RSO. The RSO generally stabilizes rent increases, so it will indicate a percentage that a landlord may increase the rent yearly. It also provides for legal reasons for eviction, or also known as the just cause evictions. There are at-fault reasons and tenant not at fault reasons. If the tenant is not at fault, then the RSO requires relocation assistance payment to the tenant. To confirm if your unit is subject to the RSO, you may go to semas.lacity.org. When you enter your address, the search results you get will give you an accordion of various items, including one titled Housing, which you see on your screen. If the Rent Stabilization Ordinance item says no, that means that that particular property has not been identified as an RSO property. If it says yes, then it means that property was identified as containing an RSO unit. You can also send the letters RSO to the number 855-880-7368 and enter your address. You will get text messages that will prompt you to enter your address, and it will confirm if that address is RSO. If the property is not subject to the RSO and is located in the city of LA, it likely will be covered by the Just Cause Ordinance, or JCO. The JCO is a new law effective January 27th of 2023. It covers all residential units not subject to the RSO, but only applies after the expiration of the initial lease agreement or after 6 months of continuous occupancy by the tenant, whichever date comes first. So if it's in the city of LA, not an RSO unit, and the tenant has been in the unit 6 months or their lease has expired, then it will be subject to the Just Cause Ordinance. The Just Cause Ordinance is very similar to the RSO. It provides for just cause eviction reasons, including tenant at fault and tenant not at fault reasons, and requires relocation assistance for no fault reasons. However, it does not regulate rent increases. On your screen, you will see the 14 legal reasons for termination of tenancy under both the RSO and the JCO. The reasons are very similar to each other, but there are slight differences between the RSO and the JCO. Reasons 1 through 7 are all RSO and JCO tenant at fault reasons for termination of tenancy. For example, non-payment of rent, violation of the lease, nuisance, illegal purpose where there's drug or gang activity at the property, failure to renew a similar lease, denial of access into the unit, or where you have a subtenant not approved. These are both RSO and JCO reasons to terminate a tenancy. Reason number 8, failure to comply with an approved tenant habitability plan, or THP, is only a termination reason under the RSO. It does not apply to just cause. And the reason for that is because the just cause ordinance does not have a THP requirement. The no fault reasons under both laws are also very similar. They include eviction for the occupancy of the owner, the owner's family, or in some situations, a resident manager. There are restrictions that apply that you should familiarize yourself with. And at the end of the presentation, we'll have some links that you can go to, and you can read the rules on owner, family, and manager occupancy. There are some tenants that cannot be evicted for these reasons, but it's a very specific rule. The laws also allow for eviction if the owner plans to demolish the units or wants to withdraw the units from the rental market. The only difference is that under the just cause ordinance, substantial renovation of the unit, it will take, I believe, 30 or more days, is also a permitted reason to terminate the tenancy. It is not a permitted reason to terminate tenancy under the RSO. The rest of the no-fault reasons apply to both laws: compliance with a government order, conversion to affordable housing, conversion of a residential hotel, and also when a building is owned by HUD and it will be sold due to foreclosure. But these number 6 is very unique, and it only applies where the owner is HUD. No-fault evictions under both the RSO and the JCO will trigger certain requirements or certain rules. First, a landlord must have a legal reason to evict a tenant, which is one of the 14 reasons that I just described in the prior slide. That notice of termination of tenancy has to state one of those reasons in writing. Second, if the eviction is for a no-fault reason, then a landlord is required to file a declaration of intent to evict with LAHD prior to serving the notice of eviction on the tenant. Third, the eviction notice that is eventually served on the tenant after the declaration is filed has to be, or the eviction notice may be served anytime after the declaration is filed. Landlords may choose to wait until after the relocation amount determination that the tenant is eligible to receive has been made. Landlords are not required to wait for this, but it may be something a landlord wants to consider so that it is clear to them ahead of time what their responsibility will be to the tenant. Please note that LS Act RSO evictions to withdraw units from the rental market are a little different. Those notices must be served on the same day that the Ellis withdrawal forms are officially filed with the department. The official filing date of Ellis it is the date that the department receives the documents and accepts the documents. And you will have an LHD analyst work closely with you to let you know specifics about that process on the Ellis Act, since it is a very unique process. For all evictions, at fault or no fault, the eviction notices themselves, meaning the 30-day notice, 60-day notice, 120-day notice for Ellis, that notice has to also be filed with LAHD within 3 business days after it is served on the tenant. So for example, if you file the declaration of intent to evict on the 1st of the month and then serve the 30 or 60-day notice on the tenant on the 2nd of the month, then you have to be sure that within 3 business days after the 2nd of the month, you file a copy of that eviction notice with the department. And lastly, no-fault eviction reasons do require relocation payment to the tenant within 15 days after the service of the termination notice. So on the slide in front of you, you will see the relocation amounts that are currently in place. These amounts are subject to change every July 1st and recently changed to the amounts that you see on your screen. The relocation amounts that a household or a unit is eligible to receive is per unit. It's not per tenant. So it's one relocation payment for the entire apartment. There are different factors that the law looks to determine the amount of relocation assistance. First, we look to whether or not the tenancy is qualified or eligible. Qualified rates are shown on the second row, and eligible rates are shown on the first row. A household is qualified if one of the occupants, one of the tenants, is a minor child or 62 years or older, or is disabled or handicapped. If none of the occupants meet any of this criteria, then the household is eligible. And the relocation amounts on the first row are the ones that apply. There are, as you can see, the other factor that we look at is the length of tenancy. So if a tenancy has been in the unit less than 3 years, they receive the relocation amounts in the first column, depending on whether they're eligible or qualified. If they've been in the unit 3 or more years, they receive the next rate of relocation amounts on the second column. We also look to low income status of a household. But the low income status really only increases the relocation amount for units or tenancies that have been in the unit for less than 3 years. As you can see from the chart, a tenant that's been in the unit for less than 3 years and is eligible would be entitled to $9,900. But if they were low income, it would jump to $12,950. Whereas a tenant, an eligible tenant that has been in the unit 3 years or more, income would not be a factor. It would be the same amount, $12,950. You will also notice in this chart that there are 2 columns at the end with different relocation amounts. One of them is the mom and pop properties, and the other one is the single family dwellings owned by a natural person. The mom and pop property relocation amounts are lower relocation amounts than the regular rates. And there are only 2 that could possibly apply. One for eligible tenants at $9,500 and one for qualified tenants at $19,150, regardless of income, regardless of length of tenancy. However, these mom and pop relocation rates are only for owner or family occupancy evictions and only for units that are owned by natural persons, meaning a corporation would not qualify for the mom and pop amounts. The owner must own no more than four dwelling units and a single family dwelling on a separate lot in the city of LA. Additionally, to qualify for the mom and pop amounts, the owner cannot have used this fee in the last 3 years. So for example, if an owner moved in a family member a year ago and used the reduced mom and pop amounts, they cannot today file for occupancy as a different family member at a different unit and claim a mom and pop rate. Instead, for the second termination of tenancy, they will have to pay their regular relocation amounts. And lastly, if the eviction is for occupancy of a family member, that family member cannot own any residential property in the city of LA. Last, and a topic that has raised a lot of questions, it's a new portion of the law, is the single family dwelling relocation amount, which is the equivalent of 1 month's rent that the tenant pays. So if the tenant pays $2,000 a month, then they would only be entitled to $2,000 in relocation. However, it's a very limited rule. It's a very limited situation where that amount would apply. It only applies where it's a standalone single family dwelling on a parcel. So that's the only unit on the entire parcel. And that unit is not subject to the RSO. Instead, it is subject to the just cause ordinance, since it is the only unit on the parcel. The unit has to be owned by a natural person, so not a corporation, and or a corporate entity that is owned by that natural person. And that person cannot own more than 4 dwelling units and a single family dwelling on a separate lot in the city of LA. If a landlord meets these requirements, then they would be eligible to pay the lower relocation amount of the equivalent of 1 month's worth of rent. So one really important aspect of the process is that the city hires a relocation consultant that takes on the responsibility of interviewing the tenant to determine the relocation amount that they are eligible to receive. As you can see from the chart, there are various factors that have to be considered, and there can be a lot of work that goes into that. So there is a city consultant that does this work. Additionally, they also help the tenant look for replacement housing. They provide free rental listings, provide free transportation to prospective units, and help answer questions about relocation payments and escrow accounts. The consultant is hired by the city of LA, but the service fees are paid by the landlord. When a landlord files a declaration of intent to evict that is required with LAHD, they also have to pay filing fees. Those filing fees are used to pay the relocation services. It's important to note that when the consultant issues their relocation determination, it is sent to both the tenant and the landlord and to LAHD. The tenant and landlord have the right to file an appeal of that decision if they do not agree with the amount that was determined. That appeal has to be filed within 15 days after the determination is made. And there will be a general manager's hearing scheduled where a third party, a hearing officer, will take testimony of the parties and review documentation to determine if the relocation determination done by the consultant was correct and should remain the same, or if it should be changed. There are two different methods of paying the relocation fees to the tenant. Once the owner has served the eviction notice, they have 15 days to pay the relocation to the tenants. And they may do so either by direct payment to the tenant. So, for example, writing a check, issuing a money order for the amount. That would be a method of direct payment to the tenant. Or a landlord may also choose to open an escrow account and deposit the relocation money within 15 days of serving the eviction notice. Escrow accounts are typically done sometimes with attorneys. Sometimes there are escrow account companies that specialize in this sort of transaction. And every once in a while, you may find a bank that's willing to do this. So the escrow account is open, the money is deposited. Really, the only one who could withdraw the money is the tenant of the unit. And that money can only be withdrawn in two ways. The tenant may either withdraw portions of the money while they're still in the unit for the purpose of paying moving expenses. For example, if they have to pay a security check or a deposit for a new unit, then they may reach out to the escrow company and withdraw that money. And of course, once they fully vacate the unit, the tenant is able to withdraw the entire balance of the relocation money that was deposited by the landlord. To do this, it's very important that the owner ensure that the tenants receive a copy of the escrow instructions within 15 days of receiving the eviction notice. The escrow instructions tell the tenant where the money was deposited, who to contact, where the telephone number, email addresses, and the rules, the process on withdrawing the money. LHD does offer sample escrow instructions that you can download from our website, and the link will be provided to you at the end of the slides. One important change effective January of 2023 is that owners may deduct rental debt from the relocation amount. And this is regardless of whether or not it's COVID related. If the rent is owed, that amount can be reduced from the relocation amount that the tenant would be entitled to receive. It is suggested that landlords who do this provide to the tenants an accounting of the amounts of the rental debt that are being deducted from the relocation amount, so that you have a clear record of what was paid, and if it wasn't paid, why it was not paid to the tenant. So how does an owner start this process? Well, it requires a declaration of intent to evict, and we have those forms available online that landlords can download. On your screen, you will see a website. If you click on that, or if you click on the image once you receive the slides via email, you will be able to see the two options on your screen, one for RSO and one for just cause. Now, depending on whether your unit is subject to the RSO or the just cause ordinance, you will select a different box. That is why the presentation started with an overview of how to determine if it's RSO or not, because it will be important when you fill out the form. Some forms are the same, some forms are different. So we recommend you start at this web page and work your way through the options. The forms that you will find on this site are for owner, family, or manager occupancy, or for compliance with a government order. The LS forms are on a different, are also on this website, but LS forms are very unique and will also require an appointment with an LHD analyst to go over the forms that a landlord fills out to ensure they're properly done, since there is a lot that an owner has to do with the Ellis forms. To file the Ellis forms, as I stated, it's a different process. We ask that owners schedule an appointment with an LHD analyst, and that appointment can be filed online using our appointment system at the site that's indicated on your page. You could also go to our main homepage, lhd.lacity.org, and navigate your way to the appointment system. Once you get to the appointment system, you will have to have an Angelino account. An Angelino account is an account that people can create to access all of the City of LA online services, including the LHD appointment services. If you do not have an Angelino account, it will be relatively easy to create one. Our website will direct you to the link where you can create an Angelino account, and from there, navigate to the appointment system. Once you're on the appointment system, you will be able to select a date, time, and the appointment type. For Ellis, you see an example on your screen. The service is Ellis for owners, preliminary appointment for occupied properties. And the location, these are virtual appointments. They're not in-person appointments, but you will be talking to your analyst and going over the forms with your analyst. And if there's a special need for an in-person appointment, it is possible to arrange one, although most people seem to prefer the virtual option. Once you have scheduled, once you're on the appointment system, you will be able to download the Ellis forms from there if you have not already done so, and you will be able to complete the forms. It is likely that you won't have time to complete the forms quickly. There is a lot of information to fill out, so we suggest you download the forms first, complete them, and then go back to the appointment system to schedule your appointment and upload the completed forms to your appointment ticket. There are instructions that can help you prepare for the appointment and can help you understand the process of filling out the forms. We have a website on the screen in front of you in blue. If you go to that website, you will see more detail on the Ellis process. And just important to point out, Ellis is specifically for RSO units. Units, it's not an Ellis eviction. Units subject to just cause can be withdrawn from the rental market. It's a different process. It's a declaration of intent to evict, and it doesn't trigger the Ellis Act. Ellis Act is specifically for RSO units. Once you have completed your forms and uploaded them to your appointment ticket, you will receive an email notification from the department confirming that we received your appointment request and giving you additional instructions. Be sure to check your spam folder in case the email goes to your spam. I mentioned previously that part of the process is a landlord has to pay filing fees for the relocation services. Not the relocation assistance fee for the tenants, but the relocation services for the consultant to make the relocation determination and provide additional services to the tenant. The fees that apply are indicated on the screen, and they are different depending on the type of tenancy that is involved. If you recall, I discussed the difference between qualified households and eligible households and mentioned how qualified households do get higher relocation amounts because they have either a disabled person, an elderly person, or a minor child living in the unit. These type of tenancies require additional services, and therefore it includes a higher rate that the owner has to pay for these services. For qualified tenants, it's $902 per unit, and for eligible is $561 per unit. Additionally, a landlord has to pay a $77 filing fee administrative fee that goes to the department. For owners who are seeking to demolish RSO units, in addition to filing the Ellis form, they also have to file a $45 per unit fee to obtain a clearance of their demolition permit. Now, this does not apply to just cause ordinance units. It only applies to RSO units when the owner is seeking to demolish them. There is a $75 fee for owner, family, or manager occupancy evictions. The $75 is for the purpose of doing the protected tenancy review, which you can read about in the website, one of the websites that will be provided to you at the end of the slides. And that applies to RSO and JCO units. And lastly, the relocation assistance dispute resolution fee is $300, but there is a waiver of the fee for low-income people. This fee is for the purpose of having an appeal hearing with a hearing officer if the tenant or the party or the owner, whoever files the appeal, disagrees with the determination by the consultant. Similar to the relocation amounts, the application fees or the filing fees are also subject to increase every July 1st. Now, how to file a declaration of intent to evict. Now that you have downloaded the forms and you fill them out, where do you go? For all no-fault evictions except for Ellis, the declarations along with the filing fees can be filed in person at one of our public counters. You're not required to schedule an appointment to go to a public counter, but we recommend you do schedule an appointment to ensure that they're able to see you timely and you're not waiting for a long period of time. The public counters are open typically Monday through Friday from 9 a.m. to 4 p.m. Some of our counters have slightly different hours, so we recommend that you check the hours before going to a public counter. If you schedule the appointment online, the system will automatically show you the hours that are available. For Ellis, even though you are also scheduling an appointment for an Ellis filing process, it's a little bit different from a counter appointment. For Ellis, you do not go to the public counter. For Ellis, you meet virtually with an LHD analyst, and you would select the service Ellis and the location virtual Ellis. The no-fault declarations of intent to evict that are not Ellis can also be mailed to the housing department to P.O. Box 17100, Los Angeles, California 90057. If you do mail your declarations, just be sure that you complete the form, the declaration form. Be sure that you also include a form that's called the Relocation Services or Demolition Monitoring Services form, and that you pay the filing fee. If you're mailing your application, the only method that is acceptable via mail would be a money order or a check made payable to the City of LA. If you go in person to a public counter, then we do also accept cash or credit cards. We ask that you submit a copy of your grant deed to verify the ownership. And if the ownership is a trust, we ask that you submit a copy of the trust instrument, which identifies the trustee, trustor, and beneficiary. And once again, just to emphasize, the Ellis forms have to be filed via an appointment with an LHD analyst, not at the public counter. And please do not mail the Ellis form prior to meeting with your LHD analyst. We do find that these meetings with the LHD analyst are very helpful and can really help a landlord ensure that the forms are properly filled out. One new law effective January of this year is that owners are required to provide the tenants a protection notice. There's two ways that an owner does this. One is by posting a copy of it in a common area at the property. And two is for new tenancies or renewal of tenancies after January of 2023. An owner should give a copy of this form to the tenant. The form can be downloaded at the website indicated on your screen, and it is available in various languages, including Spanish, Russian, and several other languages. I previously mentioned that a copy of the actual 30 or 60-day notice of termination of tenancy also has to be filed with the department within 3 business days. That is a new rule since January of this year. And those forms can be filed by sending a copy via mail with a cover sheet that you will find on the website indicated on your screen. Or you can also upload a copy of the eviction notice to an online system that was created to track these eviction notices so that an owner is able to confirm and know that that notice was indeed filed with the department. Although we do accept notices via mail or via public counter, we strongly recommend that you instead use the online system to upload them, as it is a faster process and gives you more of a guarantee of when it will be filed and that it was actually received by the department. And this requirement applies to all notices of termination of tenancy, including no-fault evictions. For non-payment of rent, these notices have to include the number of bedrooms. So that's a new requirement. So I wanted to be sure that was in the slide and to point that out to the public. So in summary, we did cover a lot of information, but it was intended to be broad and general about the process and the processing of the forms and where to find them. But there's a lot more detail out there. But today we covered the general process. So number one, that the RSO and the JCO, or the Just Cause Ordinance, requires the filing of the Declaration of Intent to evict and requires relocation payment. Number two, that the landlord will be notified, or just be aware that the landlord will be notified by LAHD via an email notification that the declaration forms were received by LAHD. So if you mailed a form or you filed it at the counter and you don't know what the status of that is, please be sure to look at your email account that you provided on the forms, because that is where we are sending notifications that we indeed received the filing. Third, tenants will also be informed of the filing. They will be contacted by the city's relocation consultant to provide the relocation services, and they will receive an explanation of the reason why these services are being offered. Four, both the landlord and tenant will be notified in writing of the relocation determination amount by the relocation consultant. Five, it is the landlord that notifies the tenant of the requirement to move out by serving them a written notice of termination of tenancy, which is done after the declaration of intent to evict is filed with the department. And of course, to emphasize, a copy of this eviction notice has to be filed with the department within 3 business days. And lastly, a landlord has to pay relocation to the tenant within 15 days that they serve the notice of termination of tenancy. So as I previously stated, we do have a list of some important sites, websites that would be good to review if you're planning on pursuing a no-fault eviction. We have the forms available for you online. We have appointments that you can schedule. We have specific information on the owner, family, manager, occupancy eviction. That's very important because there are several exceptions to the rule where the eviction cannot take place. There are protected tenants that cannot be evicted for this reason. And very important for resident managers, to do a resident manager eviction, the manager has to be required to reside on site by a law or by a affordable housing covenant. So typically units that are 16 or buildings that are 16 units or more will require an on-site manager. Less than 16 units will not require a manager. Therefore, that cannot be a reason for eviction. And affordable housing properties that have a covenant with the city will also require an on-site manager. There's information about relocation. There's a relocation bulletin that will be very helpful. It gives you all of the relocation amounts, the relocation rules, the definitions of different households. It will also, we also have a link to the escrow account instructions and a sample of the instructions that a landlord can use if they decide to deposit the money with an escrow company or with their attorney. And then lastly, I know people will have a lot of questions about this process, but if it's specific to a property, a specific scenario, a specific tenant, it's best to ask that question via our Ask Housing app. And that link is the last link on the screen that is in front of you. You can also call our hotline at 866-557-7368 if you have follow-up questions and you wish to speak to somebody. We do have a high volume of calls, but we do try to answer all the phone calls or return all the phone calls. But we are experiencing high volumes. So that's why we also offer the option to send us the question via the Ask Housing app. And if you want to sign up for future webinars, you can do so by signing up to our newsletter and you will get email notifications, or you can call our to RSVP to webinars at 213-928-9075.